Hello everyone, welcome to Retire with Lewis. My name is Lewis Ho. If this is your first time here, thank you for joining us. The purpose of this channel is to provide some useful information for the seniors. During the pandemic, a lot of people are worried that they may not be able to provide instruction to their healthcare professional how they want to be treated in the event that they are either physically or mentally not capable. Now, before we move on, I'm going to tell you a true life story. Back in 1997, I myself suffered an unknown illness and was hospitalized for about a month. Towards the end, the doctor basically gave up on me and told me that I may have only 3 more days to live. At that time, do you know how difficult it is trying to get a lawyer to come to my bedside and help me draft my last will and testament? And furthermore, my wife wouldn't even know what kind of medical treatment I want. And that is why today I want to talk to you about the importance of having a power of attorney for personal care. Please note, the information provided in this presentation are of general information only and should not be considered as providing you legal, tax, or accounting advice. You should always consult your own professional advisor before you adopt any concept here. Power of attorney is basically a legal document that you use to appoint someone to make medical or healthcare decisions for you when you are unable to do it yourself. Even though it says attorney, but this person does not have to be a lawyer. It is simply just a person that you trust to make medical and healthcare decisions for you in the future. The Ontario Substitute Decision Act allows you to appoint someone you trust to make medical and healthcare decisions for you. This person is called Attorney for Personal Care. So who can become an attorney for personal care? Well, anyone who is mentally capable and over the age of 16 can be named as an attorney for personal care. Although this person does not have to be a resident in Ontario, but make sure he is available on short notice. Also, a young person may not be able to make proper medical decisions for you, so you may want to name someone who is more mature. You need to have a certain level of mental capacity in order to make a valid power of attorney. That means you need to understand the person you appoint will be making medical and healthcare decisions for you in the future, and that he or she is truly concerned about your well-being. Advance Directive is also known as Living Will, but in Ontario, we only recognize the Advance Directive. It is a written statement on how you want your attorney to handle a medical situation, such as resuscitation, and/or your personal health care needs in the future. This statement must be signed by you and witnessed by 2 other people. Power of attorney for personal care is not the same as Advance Directive. Power of attorney for personal care is a legal document that you name someone to make medical and personal care decisions for you, where the Advance Directive is simply a medical treatment wish list. You should keep a copy of this along with your power of attorney for personal care. Here are some of the sample wishes that you can put in your Advance Directive. When there is no reasonable expectation of my recovery, I wish no cardiac resuscitation, no ventilator or respirator, no tube feeding. I prefer to live my remaining days at home if possible. I signed my organ donor card. I want maximum pain relief. Of course, you can put in many more wishes, but make sure they are reasonable and can easily be carried out by your attorney. Ontario law recognizes Advance Directive. It is binding on your attorney or other substitute decision makers. However, if you are planning to move or going to be away from the province for quite some time, then you better check to see whether you need a new document for that particular location. It is important for you to understand your power of attorney for personal care can make almost any medical decision for you. It is important for you to give this a careful consideration because when the time arises, your attorney will be making some profoundly important medical decision for you. Unlike power of attorney for property, power of attorney for personal care can only be used when you are mentally incapable of making your own care decisions. Normally, your attorney will determine whether you are mentally capable in making your own care decisions. You should put in a clause in your power of attorney that requires your attorney to seek a second assessment of your mental incapacity before he or she can make medical decisions on your behalf. Now, here's a list of what is required when you're preparing your power of attorney for personal care and Advance Directive. You need to name a primary attorney, and you need to name a contingent attorney just in case the primary is not available or unable to act. You may also want to put in some specific condition that the attorney needs to follow, such as the attorney needs to seek a second opinion from a non-attending physician before he or she can make a medical decision on your behalf. You may also want to put in a preferred treatment list in your Advance Directive. Often people ask, can power of attorney for personal care be cancelled? Yes, it can be cancelled. All you need to do is put it in writing that you wish to cancel the existing power of attorney for personal care. There's no special form for it, but you must sign it and you need 2 other people to witness it. If you fail to make the power of attorney for personal care, then your family member would automatically have the right to make the decision for you. If there's no family member available or willing, then the Office of the Public Guardian Trustee is required to make the decision for you. Now, before I conclude this episode, I would like to tell you, because of the medical incidents that I experienced, I realized life is so unpredictable. You should always get your power of attorney for personal care and Advance Directive ready in case something happened to you. Your family member will know what to do. Now, for more information, please visit Ontario Attorney General Office website. Well, thank you for joining us today. If you enjoyed the presentation and find it useful, please give us a thumbs up. And don't forget to subscribe for more presentation in the future.